Patents are powerful, but filing one doesn't always make sense. Here's exactly when you should skip it. First, if the cost doesn't justify the value. Filing and prosecuting a US patent typically takes $10,000 to $20,000 over time, and that's not including maintenance fees. If your product isn't likely to generate at least 10 times that in revenue or an enhanced valuation to your company, then it's probably not worth it. For solo entrepreneurs, bootstrap startups, or MVP stage ideas, your resources are limited. So this is the key filter you should use. Bottom line, you don't want to spend $20,000 to protect a $5,000 idea, when speed to market matters more. In certain industries like SaaS, consumer apps, digital services, speed often beats protection. Filing a patent can take 1 to 3 years to secure your rights. And during that time, a faster competitor could outlaunch you. And once the market moves on, the patent becomes irrelevant. Certain products just have a short amount of staying power. They're a fad. They're a gimmick. They don't last long. These aren't things that you should be patenting. The key thing to consider here is that if it's a race, don't stop to file the paperwork. If it's a feature and not a product. Patents are for protecting improvements, not minor details. After doing research into other inventions, looking into what's called the prior art, you might find other inventions way closer to yours than you ever imagined existed. After that research, perhaps some minor details are still different. And so you might be told it's still possible to proceed, it's still possible to get a patent. But if the minor details are what make it patentable, keep in mind that all you would be patenting are those minor details. For example, you've invented a new type of toy, that could be patent worthy. But if you've just invented a different arrangement of buttons on the toy, and that's not going to move the needle, then that's probably not worth patenting. The rule of thumb here is that if the patentable feature wouldn't meaningfully change your business, or wouldn't protect the core competitive advantage, then perhaps skip it. So what else can you do instead of patenting to protect yourself? Skipping a patent doesn't necessarily mean leaving your invention unprotected. It may just mean using smarter strategies for your situation. One approach is to use trade secrets. When you have a unique process, formula, or data that you could keep confidential, you can keep behind the scenes, and it's something that people can't figure out when they're looking at your product, then it may be possible to use trade secret law to protect them rather than patent law. For example, the Coca-Cola formula. For more than 100 years, people have not been able to reverse engineer the Coke formula. And because of that, the fact that they decided to keep it a trade secret means that they maintain protection for more than 100 years on that formula. Trade secrets work best for things like algorithms or back-end processes, things that aren't readily discoverable by the consumer. Another direction is to focus on first mover advantage. Granted, this isn't a protection scheme. It's more like a recognition of the fact that in certain fields, you putting your resources into hitting the market hard and fast is the path to success. In fast-moving spaces, being first to market and building user base traction, that can beat legal protections. Once customers are locked in, competitors are going to have a harder time catching up with you, even though you don't have patent protection. So first mover advantage can be perfect for SaaS tools that are rapidly developing, mobile apps and things of that nature, when you recognize that it's getting to the market quickly that's going to make the biggest difference. Another common thing that's overlooked is investing in brand protection. So even when you can't protect the product itself, you protect the branding with trademarks. So trademarks protect brand names, logos, other items that identify your product in the marketplace, and thereby can be used effectively to prevent competitors from confusing the public into thinking they're buying your product when they're actually buying their product. Typically, trademarks cost a couple $1,000s, far less than a patent. Trademarks are smart if your brand has significant name recognition. You being able to protect the name means that competitors can't ride on your coattails. And brand protection is especially important when you're selling products on Amazon. So here's the thing. You don't need to patent everything. Focus on protecting what really matters, whether that's through patents, trade secrets, or building a brand that people recognize. But if you choose to skip patenting, you may be giving up something valuable, so it's important to understand the risks to not patenting. So make that choice knowingly. Patents are a powerful tool, but only when used correctly. If you're not sure if your idea is patent worthy, then schedule a free strategy call with my team today. And you can grab my book, The ABA Consumer Guide to Obtaining a Patent, for a step-by-step breakdown of the patent process. And if today's video got you thinking, don't miss the next one. Can you patent an AI algorithm in 2025? That's where I break down exactly how AI tools fit into today's patent laws.